Q. A sues B for collection of a sum of money, alleging fraud in the contracting of the loan. A applies for preliminary attachment with the court. The court issues the preliminary attachment after A files a bond. While summons on B was yet unserved, the sheriff attached B's properties. Afterwards, summons was duly served on B. B moves to lift the attachment. Rule on this, 2012. A. I will grant the motion since no levy on attachment pursuant to the writ shall be enforced unless it is preceded or contemporaneously accompanied by service of summons. There must be the prior or contemporaneous service of summons with the writ of attachment. Section 5, Rule 57. Q. Bayani, an overseas worker based in Dubai, issued in favor of Agente a special power of attorney to sell his house and lot. Agente was able to sell the property but failed to remit the proceeds to Bayani, as agreed upon. On his return to the Philippines, Bayani, by way of a demand letter duly received by Agente, sought to recover the amount due him. Agente failed to return the amount as he had used it for the construction of his own house. Thus, Bayani filed an action against Agente for a sum of money with damages. Bayani subsequently filed an ex parte motion for the issuance of a writ of preliminary attachment, duly supported by an affidavit. The court granted the ex parte motion and issued a writ of preliminary attachment upon Bayani's posting of the required bond. Bayani prayed that the court's sheriff be deputized to serve and implement the writ of attachment. On November 19, 2013, the sheriff served upon Agente the writ of attachment and Agente levied on the latter's house and lot. On November 20, 2013, the sheriff served upon Agente summons and a copy of the complaint. On November 22, 2013, Agente filed an answer with motion to discharge the writ of attachment, alleging that at the time the writ of preliminary attachment was issued, he has not yet been served with summons, and therefore it was improperly issued. 2014. Is Agente correct? A. No, Agente is not correct. Section 2, Rule 57 provides that a writ of attachment may be issued ex parte upon motion with notice and hearing by the court in which the action is pending. Under the rules, the applicant of the writ is only required to submit an affidavit and to post a bond before the court can validly issue the writ of attachment. The rules do not require prior service of summons for the proper issuance of a writ of attachment. Sofia Torres versus Nicanor, Satsatin, November 25, 2009. Accordingly, the issuance of the writ of attachment is valid, notwithstanding the absence of a prior service of summons to Agente. Was the writ of preliminary attachment properly executed? 2014. No, the writ of preliminary attachment was not properly executed, although a writ of attachment may issue even before summons is served upon the defendant. The same, however, may not bind and affect the defendant until jurisdiction over his person is obtained. Davao Light and Power Company versus Court of Appeals. Thus, the writ of preliminary attachment must only be served simultaneous or at least after the service of summons to the defendant. Sofia Torres versus Nicanor Satsadin. Q. Define a temporary restraining order, TRO. Differentiate a TRO from a status quo order, 2006. A temporary restraining order is issued upon application of a party and upon the posting of the required bond. On the other hand, a status quo order may be issued motu proprio on equitable considerations and does not require the posting of a bond. Unlike a temporary restraining order or a preliminary injunction, a status quo order is more in the nature of a cease and desist order, since it neither directs the doing or undoing of acts, as in the case of prohibitory or mandatory injunctive relief. Garcia versus Mojica, September 10, 1999. What are the requisites for the issuance of A. writ of preliminary injunction and B. a final writ of injunction, 2006? A. The requisites for the issuance of a writ of preliminary injunction are 1. A right in SC or a clear and unmistakable right to be protected. 2. A violation of that right. 3. That there is an urgent and permanent act and urgent necessity for the writ to prevent serious damage. Tighe v. Laxon, March 25, 2004. A final writ of injunction may be granted if, after trial of the action, it appears that the applicant is entitled to have the act or acts complained of permanently enjoined. Section 9, Rule 58. Q. Distinguish between injunction as an ancillary remedy and injunction as a main action 2006. A. Injunction as an ancillary remedy presupposes the existence of the principal or main action. Palanca v. Court of Appeals. Its main function is to preserve the status quo until the merits can be heard and resolved. Urbanus v. Court of Appeals. On the other hand, an injunction as the main action is brought specifically to obtain a judgment perpetually restraining or commanding the performance of an act after trial. Del Mar v. Pagcor, November 29, 2000. Q. While window shopping at the mall on August 4, 2008, Dante lost his organizer including his credit card and billing statement. 2 days later, upon reporting the matter to the credit card company, he learned that a one-way airplane ticket was purchased online using his credit card for a flight to Milan in mid-August 2008. Upon extensive inquiry with the airline company, Dante discovered that the plane ticket was under the name of one Dina Marrero. Dante approaches you for legal advice. What is the proper procedure to prevent Dina from leaving the Philippines? A. The filing of an appropriate criminal action, cognizable by the RTC against Dina, and the filing in said criminal action, a motion for the issuance of a hold departure order. Number 2. Thereafter, a written request with the Commissioner of the Bureau of Immigration for a watch list order pending the issuance of the hold departure order should be filed. 3. Then the airline company should be requested to cancel the ticket issued to Dina. B. Suppose an information is filed against Dina on August 12, 2008, and she is immediately arrested. What pieces of electronic evidence will Dante have to secure in order to prove the fraudulent online transaction 2010? He will have to present A. His report to the bank that he lost his credit card. 2. The phone call log to show that he already alerted the credit card company of his loss. And 3. His credit card billing statement bearing the online ticket transaction. Q. Can a suit for injunction be aptly filed with the Supreme Court to stop the President of the Philippines from entering into a peace agreement with the National Democratic Front? 2003. A suit for injunction cannot aptly be filed with the Supreme Court to stop the President of the Philippines from entering into a peace agreement with the National Democratic Front, which is a purely political question. Madarang v. Santa Maria. The President of the Philippines is immune from suit. Q. May the RTC issue injunction without bond? 2006. Yes, if the injunction issued is a final injunction. Generally, however, a preliminary injunction may not be issued without the posting of a bond, unless exempted by the trial court, Section 4, letter B, Rule 58, or otherwise provided for by law. Q. An application for a writ of preliminary injunction with a prayer for a temporary restraining order is included in a complaint and filed in a multi-sala RTC consisting of branches 1, 2, 3, and 4. Being urgent in nature, the executive judge who was sitting in branch 1 upon the filing of the aforesaid application immediately raffled the case in the presence of the judges of branches 2, 3, and 4. The case was raffled to branch 4 and judge thereof immediately issued a temporary restraining order. Is the temporary restraining order valid? Why? 2001 and 2006. No, it is only the executive judge who can issue immediately a temporary restraining order, effective only for 72 hours from issuance. No other judge has the right or power to issue a temporary restraining order ex parte. The judge to whom the case is assigned will then conduct a summary hearing to determine whether the temporary restraining order shall be extended, but in no case beyond 20 days, including the original 72-hour period. Section 5, Rule 58. Q. May a justice of a division of the Court of Appeals issue a TRO 2006? Yes, a justice of a division of the Court of Appeals may issue a TRO as authorized under Rule 58 and by Section 5, Rule 6 of the Internal Rules of Court of Appeals, which additionally requires that the action shall be submitted on the next working day to the absent member of the division for their ratification, modification, or recall. Years of the late Justice Jose B. Reyes versus Court of Appeals, August 16, 2000. Receivership. Q. Joaquin filed a complaint against Jose for the foreclosure of a mortgage of a furniture factory with a large number of machinery and equipment. During the pendency of the foreclosure suit, Joaquin learned from reliable sources that Jose was quietly and gradually disposing of some of his machinery and equipment to a businessman friend who was also engaged in furniture manufacturing, such that, from confirmed reports Joaquin gathered, the machinery and equipment left with Jose were no longer sufficient to answer for the latter's mortgage indebtedness. In the meantime, judgment was rendered by the court in favor of Joaquin, but the same is not yet final. Knowing what Joaquin has been doing, if you were Joaquin's lawyer, what action would you take to preserve whatever remaining machinery and equipment are left with Jose? Why? 2001. To preserve whatever remaining machinery and equipment are left with Jose, Joaquin's lawyer should file a verified application for the appointment by the court of one or more receivers. The rules provide that receivership is proper in an action by the mortgagee for the foreclosure of a mortgage when it appears that the property is in danger of being wasted or dissipated or materially injured, and that its value is probably insufficient to discharge the mortgage debt. Section 1, Letter B, Rule 59, Replevin. What is a Replevin? 1999. Replevin or delivery of personal property consists in the delivery by order of the court of personal property by the defendant to the plaintiff upon the filing of a bond. Callow v. Roldan. Support pendente lite. Q. Before the RTC, A was charged with rape of his 16-year-old daughter. During the pendency of the case, the daughter gave birth to a child allegedly as a consequence of the rape. Thereafter, she asked the accused to support the child, and when he refused, the former filed a petition for support pendente lite. The accused, however, insists that he cannot be made to give such support, arguing that there is as yet no finding as to his guilt. Would you agree with the trial court if it denied the application for support pendente lite? 1999. No. The provisional remedy of support pendente lite may be granted by the RTC in the criminal action for rape. In criminal actions where the civil liability includes support for the offspring as a consequence of the crime and the civil aspect thereof has not yet been waived, reserved, or instituted prior to its filing, the accused may be ordered to provide support pendente lite to the child born to the offended party allegedly because of the crime. Section 6, Rule 61, Rules of Court. Special Civil Actions. Certiorari, Prohibition, and Mandamus. Q. Distinguish error of jurisdiction from error of judgment. 2012. An error of judgment is one which the court may commit in the exercise of its jurisdiction. Such an error does not deprive the court of jurisdiction and is correctable only by appeal, whereas an error of jurisdiction is one which the court acts without or in excess of its jurisdiction. Such an error renders an order or judgment void or voidable and is correctable by the special civil action of certiorari. De la Cruz v. Moyer, February 6, 1917, Ko Ching-yan versus Claribel, 1977, Fortich versus Corona, 1998, Aristica Ceramica versus Ciudad del Carmen Homeowners Association, 2010. Q. Compare the certiorari jurisdiction of the Supreme Court under the Constitution with that under Rule 65 of the Rules of Procedure, 2008. Under the Constitution, the certiorari jurisdiction of the Supreme Court provides for its expanded jurisdiction power of judicial power over all branches or instrumentalities of the government where there is a grave abuse of discretion amounting to lack or excess of jurisdiction, as agencies and instrumentalities provided in Section 1, second paragraph, Article 8 of the 1987 Constitution. The petition is filed under Rule 45 of the Rules of Court, and the writ is directed not only to tribunal, board, or officer exercising judicial or quasi-judicial functions, and the period fixed for availing of the remedy is within 30 days from receipt of the copy of the decision or the ruling in question, but under Rule 65 of the Rules of Court. The certiorari jurisdiction of the Supreme Court is limited to acts done without or in excess of jurisdiction or grave abuse of discretion amounting to lack or excess of jurisdiction by a tribunal, board, or officer exercising judicial or quasi-judicial functions only, and the period fixed for availing of the remedy is not later than 60 days from notice of judgment, order, or resolution in question. Sections 1 and 4, Rule 65. Q. AB mortgaged his property to CD. AB failed to pay his obligation and CD filed an action for foreclosure of mortgage. After trial, the court issued an order granting CD's prayer for foreclosure of mortgage and ordering AB to pay CD the full amount of the mortgage debt, including interest and other charges, not later than 120 days from date of receipt of the order. AB received the order on August 10, 1999. No other proceeding took place thereafter. On December 20, 1999, AB tendered the full amount adjudged by the court to CD, but the latter refused to accept it on the ground that the money was tendered beyond the 120-day period granted by the court. AB filed a motion in the same court praying that CD be directed to receive the amount tendered by him on the ground that the order does not comply with the provisions of Section 2, Rule 68 of the Rules of Court, which give AB 120 days from entry of judgment and not from date of receipt of the order. The court denied his motion on the ground that order had already become final and can no longer be amended to conform with Section 2, Rule 68. Aggrieved, AB files a petition for certiorari against the court and CD. Will the petition for certiorari prosper? Explain. 2000. Yes, the court erred in issuing an order granting CD's prayer for foreclosure of mortgage and ordering AB to pay CD the full amount of the mortgage debt, including interest and other charges, not later than 120 days from receipt of the order. The court should have rendered a judgment which is appealable. Since no appeal was taken, the judgment became final on August 25, 1999, which is the date of entry of judgment, Section 2, Rule 36. Hence, AB had up to December 24, 1999, within which to pay the amount due, Section 2, Rule 68. The court gravely abused its discretion amounting to lack or excess of jurisdiction in denying AB's motion praying that CD be directed to receive the amount tendered. Q. The defendant was declared in default in the RTC for his failure to file an answer to a complaint for a sum of money on the basis of the plaintiff's ex parte presentation of evidence. Judgment by default was rendered against the defendant. The defendant judgment was served on the defendant on October 1, 2001. On October 10, 2001, he files a verified motion to lift the order of default and to set aside the judgment. In his motion, the defendant alleged that immediately upon receipt of the summons, he saw the plaintiff and confronted him with his receipt evidencing his payment, and that the plaintiff assured him he would instruct his lawyer to withdraw the complaint. The trial court denied the defendant's motion because it was not accompanied by an affidavit of merit. The defendant filed a special civil action for certiorari under Rule 65, challenging the denial order. Is certiorari under 65 the proper remedy? Why? Yes, the petition for certiorari under Rule 65 filed the defendant is the proper remedy because appeal is not a plain, speedy, and adequate remedy in the ordinary course of law. In appeal, the defendant in default can only question the decision in the light of the evidence of the plaintiff. The defendant cannot invoke the receipt to prove payment of his obligation to the plaintiff. B. Did the trial court abuse its discretion or act without or in excess of its jurisdiction in denying the defendant's motion to lift the order of default judgment? 2002. Yes, the trial court gravely abused its discretion or acted without or in excess of jurisdiction in denying defendant's motion because it was not accompanied by a separate affidavit of merit. In his verified motion to lift the order of default and to set aside the judgment, the defendant alleged that immediately upon the receipt of the summons, he saw the plaintiff and confronted him with its receipt showing payment, and that the plaintiff assured him that he would instruct his lawyer to withdraw the complaint. Since the good defense of the defendant was already incorporated in the verified motion, there was no need for a separate affidavit of merit. Capus v. Court of Appeals. Bago v. Court of Appeals. Q. Explain each mode of certiorari. As a mode of appeal from regional trial court or the Court of Appeals to the Supreme Court. A petition for review on certiorari under Rule 45 is a mode of appeal on pure questions of law from a judgment or final order or resolution of the regional trial court or the Court of Appeals to the Supreme Court. As special civil action from the regional trial court or the Court of Appeals to the Supreme Court. A special civil action for certiorari under Rule 65 is an original action from the regional trial court or the Court of Appeals to the Supreme Court against any tribunal, board of officer exercising judicial or quasi-judicial functions, raising the issue of lack or excess of jurisdiction or grave of abuse of discretion amounting to lack or excess of jurisdiction. There being no appeal or any plain, speedy, and adequate remedy in the ordinary course of law. C. As a mode of review of the decisions of the National Labor Relations Commission and the Constitutional Commission's 2006. The mode of a review of the decision of the NLRC is via a special civil action for certiorari under Rule 65, but pursuant to the hierarchy of the courts enunciated in the case of St. Martin's Funeral Homes versus NLRC, September 16, 1998. The same should be filed in the Court of Appeals. The mode of review of the decisions of two constitutional commissions, the Commission on Elections and the Commission on Audit, as provided under Rule 64, is a special civil action for certiorari under Rule 65. Decisions of the Civil Service Commission, however, are reviewable by petition for review to be filed with the Court of Appeals under Rule 43. Q. Differentiate certiorari as an original action from certiorari as a mode of appeal, 1998-1999. Certiorari is an original action and certiorari as a mode of appeal may be distinguished as follows. A. The first is a special civil action under Rule 65, while the second is an appeal to the Supreme Court from the Court of Appeals, Sandiganbayan, and the Regional Trial Court under Rule 45. B. The first can be filed only on the grounds of lack or excess of jurisdiction or grave abuse of discretion tantamount to lack or excess of jurisdiction, while the second is based on the errors of law of the lower court. C. The first should be filed within 60 days from notice of the judgment, order, or resolution sought to be assailed, Section 4, Rule 65, while the second should be filed within 15 days from notice of the judgment or final order or resolution appealed from, or of the denial of the petitioner's motion for new trial or reconsideration filed in due time after notice of the judgment. D. The first cannot generally be availed of as a substitute for a lost appeal under Rule 40, 41, 42, 43, and 45. Letter E. Under the first, the lower court is impleaded as a party respondent, Section 5, Rule 65, while under the second, the lower court is not impleaded, Section 4, Rule 45. Q. May the aggrieved party file a petition for certiorari in the Supreme Court under Rule 65 of the 1997 Rules of Civil Procedure instead of filing a petition for review on certiorari under Rule 45 thereof for the nullification of a decision of the Court of Appeals in the exercise either of its original or appellate jurisdiction. Explained 1999-2005. To nullify a decision of the Court of Appeals, the aggrieved party should file a petition for review on certiorari in the Supreme Court under Rule 45 of the Rules of Court instead of filing a petition for certiorari under Rule 65, except under very exceptional circumstances. A long line of Supreme Court decisions, too numerous to mention, holds that certiorari is not a substitute for a lost appeal. It should be noted, however, when the Court of Appeals imposes the death penalty or a lesser penalty for offenses committed on such occasion, appeal for a petition for review or ordinary appeal. In cases when the Court of Appeals imposes reclusion perpetua, life imprisonment, or a lesser penalty, appeal is by notice of appeal filed with the Court of Appeals. Q. After an information for rate was filed in the RTC, the DOJ Secretary acting on the accused petition for review reversed the investigating prosecutor's finding of probable cause. Upon order of the DOJ Secretary, the trial prosecutor filed a motion to withdraw information, which the judge granted. The order of the judge stated on the following: based on the review by the DOJ Secretary of the findings of the investigating prosecutor during the preliminary investigation, the court agrees that there is no sufficient evidence against the accused to sustain the allegation in the information. The motion to withdraw information is therefore granted. If you were the private prosecutor, what would you do? 2003-2012. If I were the private prosecutor, I would file a petition for certiorari under Rule 65 with the Court of Appeals. Cerezo v. People. It is well settled that when the trial court is confronted with a motion to withdraw an information on the ground of lack of probable cause to hold the accused for trial based on a resolution of the DOJ Secretary, the trial court has the duty to make an independent assessment of the merits of the motion. It may either agree or disagree with the recommendation of the Secretary. Reliance alone on the resolution of the Secretary would be an abdication of the trial court's duty and jurisdiction to determine a prima facie case. The court must itself be convinced that there is indeed no sufficient evidence against the accused. Otherwise, the judge acted with grave abuse of discretion if he grants the motion to withdraw information by the trial prosecutor. Harold Tomargo v. Romulo Awingan, GR 177, 27, January 2010. Q. After plaintiff in an ordinary civil action before the RTC, ZZ has completed presentation of its evidence. Defendant, without prior leave of court, move for dismissal of plaintiff's complaint for insufficiency of plaintiff's evidence. After due hearing of the motion and the opposition thereto, the court issued an order reading as follows: the court hereby grants defendant's motion to dismiss and accordingly orders the dismissal of plaintiff's complaint with a cost tax against him. It is so ordered. Is the order of dismissal valid? May plaintiff properly take an appeal? Reason 2004. The order or decision is void because it does not state findings of fact and of law as required by Section 14, Article 8 of the Constitution and Section 1, Rule 36. Being void, appeal is not available. The proper remedy is certiorari under Rule 65. Q. Jamie was convicted for murder by the Regional Trial Court of Davao City and a decision promulgated on September 30, 2015. On October 5, 2015, Jamie filed a motion for new trial on the ground that errors of law and irregularities prejudicial to his rights were committed during his trial. On October 7, 2015, the private prosecutor, with the conformity of the public prosecutor, filed an opposition to Jamie's motion. On October 9, 2015, the court granted Jamie's motion. On October 12, 2015, the public prosecutor filed a motion for reconsideration. The court issued an order dated October 16, 2015, denying the public prosecutor's motion for reconsideration. The public prosecutor received his copy of the order of denial on October 20, 2015, while the private prosecutor received his copy on October 26, 2015. What is the remedy available to the prosecution from the court's order granting Jamie's motion for a new trial? The remedy of the prosecution is to file a petition for certiorari under Rule 65 of the Rules of Court, because the denial of a motion for reconsideration is merely an interlocutory order and there is no plain, speedy, and adequate remedy under the course of law. Be that as it may be argued that appeal is the appropriate remedy for an order denying a motion for reconsideration of an order granting a motion for new trial, because an order denying a motion for reconsideration was already removed in the enumeration of matters that cannot be a subject of an appeal under Section 1, Rule 41 of the Rules of Court. In what court and within what period should a remedy be availed of? Following the principle of judicial hierarchy, the petition for certiorari should be filed before the Court of Appeals within 60 days from receipt of the copy of the order of denial of the public prosecutor's motion for reconsideration, or on October 20, 2015. C. Who should pursue the remedy 2015? The Office of the Solicitor General OSG should pursue the remedy. In criminal proceedings on appeal in the Court of Appeals or in the Supreme Court, the authority to represent the people is vested solely in the Solicitor General. Under Presidential Decree No. 4478, among the specific powers and functions of the OSG is to represent the government and the Supreme Court and the Court of Appeals in all criminal proceedings. This provision has been carried over to the Revised Administrative Code, particularly in Book 4, Title 3, Chapter 12 thereof. Without doubt, the OSG is the appellate counsel of the people of the Philippines in all criminal cases. Carino v. De Castro, April 30, 2008. Q. The Ombudsman found probable cause to charge with plunder the provincial governor, vice governor, treasurer, budget officer, and accountant. An information for plunder was filed with the Sandigan Bayan against the provincial officials, except for the treasurer, who was granted immunity when he agreed to cooperate with the Ombudsman in the prosecution of the case. Immediately, the governor filed with the Sandigan Bayan a petition for certiorari against the Ombudsman, claiming there was grave abuse of discretion in excluding the treasurer from the information. Was the remedy taken by the governor correct? No. The remedy taken by the governor is not correct. The petition for certiorari is a remedy that is only available when there is no plain, speedy, and adequate remedy under the ordinary course of law. Hence, the governor should have filed a motion for reconsideration. Besides, there is no showing that the Ombudsman committed grave abuse of discretion in granting immunity to the treasurer who agreed to cooperate in the prosecution of the case. Will the writ of Mandamus lie to compel the Ombudsman to include the treasurer in the information 2015? No. Mandamus will not lie to compel the Ombudsman to include the treasurer in the information. In matters involving exercise of judgment and discretion, Mandamus may only be resorted to in order to compel respondent tribunal, corporation, board, officer, or person to take action, but it cannot be used to direct the manner or particular way discretion is to be exercised, or to compel the retraction or reversal of an action already taken in the exercise of judgment or discretion. Ampatuan Jr. v. Secretary de Lima. Evidently, the Ombudsman Act of granting the treasurer immunity from prosecution under such terms and conditions as it may determine, is a discretionary duty that may not be compelled by the extraordinary writ of Mandamus, Section 17 RA 6770. Mandamus. Q. Petitioner Fabian was appointed election registrar of the municipality of Sevilla, supposedly to replace the respondent election registrar Pablo, who was transferred to another municipality without his consent and who refused to accept his aforesaid transfer, much less to vacate his position in Bogotá as election registrar, as in fact he continued to occupy his aforesaid position and exercise his functions thereto. Petitioner Fabian then filed a petition for mandamus against Pablo, but the trial court dismissed Fabian's petition, contending that quo warranto is the proper remedy. Is the court correct in its ruling? Why? 2000 and why? Yes, the court is correct in its ruling. Mandamus will not lie. This remedy applies only where petitioner's right is founded clearly in law, not when it is doubtful. Pablo was transferred without his consent, which is tantamount to removal without cause, contrary to the fundamental guarantee on non-removal except for cause. Considering that Pedro continued to occupy the disputed position and exercise his functions therein, the proper remedy is quo warranto, not mandamus. Garces v. Court of Appeals. Q. In 1996, Congress passed Republic Act 8189, otherwise known as the Voters Registration Act of 1996, providing for computerization of elections. Pursuant thereto, the Comelec approved the Voters Registration and Identification System (VRIS) project. It issued invitations to pre-qualify and bid for the project. After the public bidding, Photokina was declared the winning bidder with a bid of 6 billion and was issued a notice of award. But Comelec Chairman Jenner Go objected to the award on the ground that under the Appropriations Act, the budget for the Comelec's modernization is only 1 billion. He announced to the public that the VRIS project has been set aside. Two commissioners sided with Chairman Go, but the majority voted to uphold the contract. Meanwhile, Photokina filed with the RTC a petition for mandamus to compel the Comelec to implement the contract. The Office of the Solicitor General OSG, representing Chairman Go, opposed the petition on the ground that mandamus does not lie to enforce contractual obligations. During the proceedings, the majority commissioners filed a manifestation that Chairman Go was not authorized by the Comelec and Bank to oppose the petition. Is a petition for mandamus an appropriate remedy to enforce contractual obligation? 1999, 2006. No, the petition for mandamus is not an appropriate remedy because it is not available to enforce a contractual obligation. Mandamus is directed only to ministerial acts, directing or commanding a person to do a legal duty. Comelec v. Quijano Padilla, September 18, 2002. Q. A files a complaint against B for recovery of title and possession of land situated in Makati with the RTC of Pasig. B files a motion to dismiss for improper venue. The RTC Pasig judge denies B's motion to dismiss, which obviously was incorrect, alleging that the RTC judge unlawfully neglected the performance of an act which the law specifically enjoins as a duty resulting from an office. A files a petition for mandamus against the judge. Will mandamus lie? Reasons 2012. No, mandamus will not lie. The proper remedy is a petition for prohibition. Serena v. Sandigan Bayan. The dismissal of the case based on improper venue is not a ministerial duty. Mandamus does not lie to compel the performance of a discretionary duty. Nilo Paloma v. Danilo Mora. Q. A group of businessmen formed an association in Cebu City calling itself Cars C to distribute or sell cars in said city. It did not incorporate itself under the law, nor did it have any government permit or license to conduct its business as such. The Solicitor General filed before RTC in Manila a verified petition for quo warranto, questioning and seeking to stop the operations of Car's company. The latter filed a motion to dismiss the petition on the ground of improper venue, claiming that its main office and operation are in Cebu and not in Manila. Is the contention of Car's company correct? 2001. No. As expressly provided in the rules, when the Solicitor General commences the action for quo warranto, it may not be brought in an RTC in the City of Manila, as in this case, in the Court of Appeals or in the Supreme Court, Section 7, Rule 66. Expropriation. May Congress enact a law providing that a 5,000 square meter lot, a part of the UST compound in Sampaloc, Manila, be expropriated for the construction of a park in honor of former City Mayor Arsenio Lacson? As compensation to UST, the City of Manila shall deliver its 5-hectare lot in Santa Rosa, Laguna, originally intended as a residential subdivision for the Manila City Hall. 2006. Yes, Congress may enact a law expropriating property provided that it is for public use and with just compensation. In this case, the construction of a park is for public use. Sina versus Manila Railroad Company. The planned compensation, however, is not legally tenable, as the determination of just compensation is a judicial function. No statute, decree, or executive order can mandate that the determination of just compensation by the executive or legislative departments can prevail over the court's findings. Export Processing Zone Authority versus Tulay. In addition, compensation must be paid in money. Esteban versus Honorio. Foreclosure of real estate mortgage. A. Is the buyer in the auction sale arising from an extrajudicial foreclosure entitled to a writ of possession even before the expiration of the redemption period? If so, what is the action to be taken? Answer: yes. The buyer in the auction sale is entitled to a writ of possession even before the expiration of the redemption period upon the filing of an ex parte petition for issuance of a writ of possession and posting of the appropriate bond. Under Section 7 of Act No. 3135 as amended, the writ of possession may be issued to the purchaser in a foreclosure sale either within the 1-year redemption period upon the filing of a bond or after the lapse of the redemption period without need of a bond. LZK Holding and Development Corporation versus Planters Development Bank. Stated otherwise, Section 7 of Act 3135 as amended also refers to a situation wherein the purchaser seeks possession of the foreclosed property during the 12-month period for redemption. Hence, upon the purchaser's filing of the ex parte petition and posting of the appropriate bond, the RTC shall, as a matter of course, order the issuance of the writ of possession in favor of the purchaser. Spouses Nicasio versus Marquez and Anita Marquez. Letter B. After the period of redemption has lapsed and the title to the lot is consolidated in the name of the auctioned buyer, is he entitled to the writ of possession as a matter of right? If so, what is the action to be taken? Yes, the auction buyer is entitled to a writ of possession as a matter of right. It is settled that the buyer in a foreclosure sale becomes the absolute owner of the property purchased if it is not redeemed within a period of 1 year after the registration of the certificate of sale. He is therefore entitled to the possession of the property and can demand it at any time following the consolidation of ownership in his name and the issuance to him of a new transfer certificate of title. In such a case, the bond required in Section 7 of Act 3135 is no longer necessary. Possession of the land then becomes an absolute right of the purchaser as confirmed owner. Upon proper application and proof of title, the issuance of the writ of possession becomes a ministerial duty of the court. LZK Holdings and Development Corporation versus Planters Development Bank. Letter C. Suppose that after the title to the lot has been consolidated in the name of the auctioned buyer, said buyer sold the lot to a third party without first getting a writ of possession. Can the transferee exercise the right of the auction buyer and claim that it is a ministerial duty of the court to issue a writ of possession in his favor? 2016. Yes, the transferee can exercise the right of the auction buyer. A transferee or successor in interest of the auction buyer by virtue of the contract of sale between them is considered to have stepped into the shoes of the auction buyer. As such, the transferee is necessarily entitled to avail of the provisions of Section 7 of Act 3135 as amended, as if he is the auction buyer. Espouses Gustuzlau versus Jenson. When the lot purchased at a foreclosure sale is in turn sold or transferred, the right to the possession thereof, along with all other rights of ownership, transfers to its new owner. Espouses Gallant versus Velasquez. Ergo, it is a ministerial duty of the court to issue a writ of possession in favor of the transferee of the auction buyer. Forcible entry and unlawful detainer. Q. A borrowed from the Development Bank of the Philippines (DBP) the amount of 1 million secured by a title land of his friend B, who however did not assume personal liability for the loan. A defaulted and DBP filed an action for judicial foreclosure of the real estate mortgage, impleading A and B as defendants. In due course, the court rendered judgment directing A to pay the outstanding account of 1.5 million, principal plus interest, to the bank. No appeal was taken by A on the decision within the reglementary period. A failed to pay the judgment debt within the period specified in the decision. Consequently, the court ordered the foreclosure sale of the mortgage land. In that foreclosure sale, the land was sold to the DBP for 1.5 million. The sale was subsequently confirmed by the court, and the confirmation of the sale was registered with the Registry of Deeds on January 5, 2002. On 10th of January 2003, the bank filed an ex parte motion with the court for the issuance of a writ of possession to oust B from the land. It also filed a deficiency claim for 800,000 pesos against A and B. The deficiency claim was opposed by A and B. Resolve the motion for the issuance of a writ of possession. A. In judicial foreclosure of banks such as DBP, the mortgagor or of dator whose real property has been sold on foreclosure has the right to redeem the property sold within 1 year after the date or registration of the sale. However, the purchaser at the auction sale has the right to obtain a writ of possession after the finality of the order confirming the sale. Section 3, Rule 68, Section 47 RA 8791, the General Banking Law of 2000. The motion for writ of possession, however, cannot be filed ex parte. There must be a notice of hearing. B. Resolve the deficiency claim of the bank. 2003. The deficiency claim of the bank may be enforced against the mortgage debtor A, but it cannot be enforced against B, the owner of the mortgage property who did not assume personal liability for the loan. Q. On ejectment. On January 10, 1990, X leased the warehouse of A under a lease contract with a period of 5 years. On June 8, 1996, A filed an unlawful detainer case against X without a prior demand for X to vacate the premises. Can X contest his ejectment on the ground that there was no prior demand for him to vacate the premises? Answer: yes. X can contest his ejectment on the ground that there was no prior demand to vacate the premises. Section 2, Rule 70, Castellan versus Tomasi. B. In the case that municipal trial court renders judgment in favor of A, is the judgment immediately executory? 1997. Yes, because the judgment of the municipal trial court against the defendant X is immediately executory upon motion unless an appeal has been perfected. A supersedeas bond has been filed and the periodic deposits of current rentals, if any, as determined by the judgment, will be made with the appellate court. Section 19, Rule 70. Unlawful detainer. Q. In an action for unlawful detainer in the Municipal Trial Court (MTC), Defendant X raised in his answer the defense that Plaintiff A is not the real owner of the house subject of the suit. X filed a counterclaim against A for the collection of a debt of 80,000 pesos, plus accrued interest of 15,000 and attorney's fees of 20,000. Is X defense tenable? No. X defense is not tenable if the action is filed by a lessor against a lessee. However, if the right of possession of the plaintiff depends on his ownership, then the defense is tenable. Does the MTC have jurisdiction over the counterclaim? 1998. The counterclaim is within the jurisdiction of the Municipal Trial Court, which does not exceed 100,000 pesos, because the principal demand is 80,000 pesos, exclusive of interest and attorney's fees. Section 33, BP 129, as amended. However, inasmuch as all actions of forcible entry and unlawful detainer are subject to summary procedure, and since the counterclaim is only permissive, it cannot be entertained by the Municipal Trial Court. Section 1, Revised Rule on Summary Procedure. Q. The spouses 1 reside in Quezon City. With their lottery winnings, they purchased a parcel of land in Tagaytay City for 100,000 pesos. In a recent trip to their Tagaytay property, they were surprised to see hastily assembled shelters of flight materials occupied by several families of informal settlers who were not there when they last visited the property 3 months ago. To rid the spouses Tagaytay property of these informal settlers, briefly discuss the legal remedy you as their counsel would use, the steps you would take, the court where you would file your remedy if the need arises, and the reasons for your actions. 2013. As counsel of spouses 1, I will file a special civil action for forcible entry. The rules of court provide that a person deprived of the possession of any land or building by force, intimidation, strategy, or stealth may at any time within 1 year after such withholding of possession bring an action in the proper municipal trial court where the property is located. This action, which is summary in nature, seeks to recover the possession of the property from the defendant which was illegally withheld by the latter. Section 1, Rule 70. An ejectment case is designed to restore, through summary proceedings, the physical possession of any land or building to one who has been illegally deprived of such possession without prejudice to the settlement of the parties opposing claims of juridical possession in appropriate proceedings. Heirs of Agapito T. Olarte and Angela Olarte et al. Versus Office of the President of the Philippines et al. In Abad versus Forales, the Supreme Court held that 2 allegations are indispensable in actions for forcible entry to enable first-level courts to acquire jurisdiction over them. First, that the plaintiff had prior physical possession of the property, and second, that the defendant deprived him of such possession by means of force, intimidation, threats, strategy, or stealth. However, before instituting the said action, I will first endeavor to amicably settle the controversy with the informal settlers before the appropriate lupon or barangay chairman. If there is no agreement reached after mediation and conciliation under the Katarungang Pambarangay Law, I will secure a certificate to file action and file the complaint for ejectment before the MTC of Tagaytay City, where the property is located, since ejectment suit is a real action regardless of the value of the property to be recovered or claim for unpaid rentals. BP 129 and Section 1, Rule 4. In the aforementioned complaint, I will allege that spouses 1 had prior physical possession and that the dispossession was due to force, intimidation, and stealth. That complaint will likewise show that the action was commenced within a period of 1 year from unlawful deprivation of possession, and that spouses 1 is entitled to restitution of possession together with damages and costs. Q. BB files a complaint for ejectment in the MTC on the ground of non-payment of rentals against JJ. After 2 days, JJ files in the RTC a complaint against BB for a specific performance to enforce the option to purchase the land subject of the ejectment case. What is the effect of JJ's action on BB's complaint. Explain 2000. There is no effect. The ejectment case involves possession de facto only. The action to enforce the option to purchase will not suspend the action of ejectment for non-payment of rentals. Whittleman Auto Supply versus Court of Appeals. Q. Landlord, a resident of Quezon City, entered into a lease contract with tenant, a resident of Marikina City, over a residential house in Las Piñas City. The lease contract provided, among others, for a monthly rental of $25,000 plus 10% interest rate in case of non-payment of its due date. Subsequently, landlord migrated to the United States of America, but granted in favor of his sister Maria a special power of attorney to manage the property and file and defend suits over the property rented out to tenant. Tenant failed to pay the rentals due for 5 months. Maria asked her legal advice on how she can expeditiously collect from tenant the unpaid rentals plus interest due. What judicial remedy would you recommend to Maria? I will advise Maria to immediately send a letter to the tenant demanding the immediate payment of the unpaid rentals plus interest due. If the tenant refuses, Maria can avail of any of the following remedies. 1. A complaint under AM number 08-8-7-SC or the rules of procedure for small claims cases. Maria should nonetheless waive the amount in excess of 100,000 pesos in order for her to avail of the remedy under the said rules. Number 2. A complaint for collection of sum of money under the rules and summary procedure, since Maria is only claiming the unpaid rentals and interest due from tenant. Number 3. If the tenant refuses or is unable to pay the rentals within 1 year from the last demand to vacate and pay, I would advise Maria to file an action for unlawful detainer. Letter B. Where is the proper venue for the judicial remedy which you recommended? Number 1. If Maria decides to file a complaint for collection of sum of money under the rules of summary procedure or small claims, the venue is the residence of the plaintiff or defendant at the election of the plaintiff, Section 2, Rule 4. Hence, it may be in Quezon City or Marikina City at the option of Maria. Number 2. If Maria files an action for unlawful detainer, the same shall be commenced and tried in the municipal trial court of the municipality of or city wherein the real property involved or a portion thereof is situated. Section 1, Rule 4. Therefore, the venue is Las Piñas City. Letter C. If Maria insists on filing an ejectment suit against tenant when do you reckon the 1 year period within which to file the action 2014? The reckoning point for determining the 1 year period within which to file the action is the receipt of the last demand to vacate and pay. Section 2, Rule 70. Q. Mr. Sheriff attempts to enforce a writ of execution against X, a tenant in a condominium unit who lost in an ejectment case. X does not want to budge and refuses to leave. Y, the winning party, moves that X be declared in contempt, and after hearing, the court held X guilty of indirect contempt. If you were X lawyer, what would you do? Y, 2012. If I were X lawyer, I would file a petition for certiorari under Rule 65. The judge should not have acted on Y's motion to declare X in contempt. The charge of indirect contempt is initiated through a verified petition. Section 4, Rule 71. The writ was not directed to X, but to the sheriff, which was directed to deliver the property to Y. As the writ did not command the judgment debtor to do anything, he cannot be guilty of the facts described in Rule 71, which is disobedience of or resistance to a lawful writ, process, order, judgment, or command of any court. The proper procedure is for the sheriff to oust X availing of the assistance of peace officers pursuant to Section 10, letter C of Rule 39, Lipa versus Tutuan. Contempt. Q. A filed a complaint for the recovery of ownership of land against B, who was represented by her counsel X. In the course of the trial, B died. However, X failed to notify the court of B's death. The court proceeded to hear the case and rendered judgment against B. After the judgment became final, a writ of execution was issued against C, who, being B's sole heir, acquired the property. Did the failure of counsel acts to inform the court of B's death constitute direct contempt? Answer is no. It is not direct contempt under Section 1 of Rule 71, but it is an indirect contempt within the purview of Section 3 of Rule 71. The lawyer can also be subject of disciplinary action. Section 16, Rule 3. Special proceedings. Writ of habeas corpus. Q. Roxanne, a widow, filed a petition for habeas corpus with the Court of Appeals against Mayor Amor, who is allegedly detaining her 18-year-old son Bong without authority of law. After Amor had filed a return alleging the cause of detention of Bong, the Court of Appeals promulgated a resolution remanding the case to the RTC for a full-blown trial due to the conflicting facts presented by the parties in their pleadings. In directing the remand, the Court of Appeals relied on Section 9, Number 1, in relation to Section 21 of BP 129, conferring upon said court the authority to try and decide habeas corpus cases concurrently with the RTCs. Did the Court of Appeals act correctly in remanding the petition to the RTC? Why, 1993. No, because while the CA has original jurisdiction over habeas corpus concurrent with the RTCs, it has no authority for remanding to the latter original actions filed with the former. On the contrary, the CA is specifically given the power to receive evidence and perform any and all acts necessary to resolve factual issues raised in cases falling within its original jurisdiction. When not proper, applicable. Q. A was arrested on the strength of a warrant of arrest issued by the RTC in connection with an information for homicide. W. The live-in partner of A filed a petition for habeas corpus against A's jailer and police investigators with the Court of Appeals. Does W have the personality to file the petition for habeas corpus? Answer: yes. W, the live-in partner of A, has the personality to file the petition for habeas corpus because it may be filed by some person in his behalf. Section 3, Rule 102. B. Is the petition tenable? 1998. No. The petition is not tenable because the warrant of arrest was issued by a court which had jurisdiction to issue it. Section 4, Rule 102. Q. Widow A and her two children, both girls, aged 8 and 12 years old, reside in Angeles City, Pampanga. A leaves her two daughters in their house at night because she works in a brothel as a prostitute. Realizing the danger of the morals of these two girls, B, the father of the deceased husband of A, files a petition for habeas corpus against A for the custody of the girls in the family court in Angeles City. In said petition, B alleges that he is entitled to the custody of the two girls in the family court in Angeles City. In said petition, B alleges that he is entitled to the custody of the two girls because of their mother living a disgraceful life. The court issues the writ of habeas corpus. When A learns of the petition and the writ, she brings her two children to Cebu City. At the expense of B, the sheriff of the said family court goes to Cebu City and serves the writ on A. A files her comment on the petition raising the following defenses. A. The enforcement of the writ of habeas corpus in Cebu City is illegal. Answer: the writ of habeas corpus issued by the family court in Angeles City may not be legally enforced in Cebu City because the writ is enforceable only within the judicial region to which the family court belongs, unlike the writ granted by the Supreme Court or Court of Appeals, which is enforceable anywhere in the Philippines. Section 20 of the Rule of Custody of Minors and writ of habeas corpus in relation to custody of minors, AM number 030404 SC. Or Section 4, Rule 102, Rules of Court. Letter B. B has no personality to institute the petition. Resolve the petition in the light of the above defense of A. 2003. B, the father of the deceased husband of A, has the personality to institute the petition for habeas corpus of the two minor girls because the grandparent has the right of custody as against the mother, who is a prostitute. Section 2 and 13. Q. Hercules was walking near a police station when a police officer signaled for him to approach. As soon as Hercules came near, the police officer frisked him, but the latter found no contraband. The police officer told Hercules to get inside the police station. Inside the police station, Hercules asked the police officer, "Sir, may problema po ba?" Instead of replying, the police officer locked up Hercules inside the police station jail. What is the remedy available to Hercules to secure his immediate release from detention? 2015. The remedy available to Hercules is to file a petition for habeas corpus questioning the illegality of his warrantless arrest. The writ of habeas corpus shall extend to all cases of illegal confinement or detention by which any person is deprived of liberty. Section 1, Rule 102.